Welcome to our video on the immigration dilemma facing binational couples, especially when the foreign spouse is self-employed. Today we will compare the trade-offs between speed and income security when choosing between adjustment of status in the United States, consular processing abroad, and the rare direct consular filing option. We will focus on timelines, legal risks, and work authorization implications. Let us begin. First, let us frame the core issue. Many couples must decide between being together quickly in the United States and preserving the foreign spouse's ability to work legally without interruption. This matters especially when the foreign spouse is self-employed and cannot afford extended downtime. With that context, we will move on to the agenda and map the journey ahead. Before proceeding, here is a legal disclaimer. This content is for general educational purposes only and does not constitute legal advice. Immigration law is complex and fact-specific. You should consult a licensed immigration attorney to evaluate your unique circumstances. Now, with that out of the way, we can continue to the agenda. Next, here is our roadmap. We will cover the dilemma, Option 1 with K-1 or adjustment of status, Option 2 with consular processing, and the rare direct consular filing. Then we will review decision steps, including the U.S. domicile requirement, test your knowledge with quick quizzes, and wrap up with key takeaways. Let us start with the big picture. To begin, consider the big picture. The central trade-off is speed versus income security. Under Option 1, couples reunite quickly in the United States, but the foreign spouse cannot work until an employment authorization document or green card is approved. This period commonly exceeds 6 months and can be longer. Under Option 2, couples wait apart while pursuing consular processing. The benefit is that the foreign spouse enters the United States as a permanent resident and can work immediately from the day of entry. Finally, direct consular filing exists as a narrow exception for extraordinary circumstances, and acceptance is discretionary. With this overview in mind, let us examine each option more closely. Now let us examine Option 1, which includes entering on a K-1 fiancé visa or entering on a visitor visa and then adjusting status after marriage. The advantage is speed and immediate cohabitation. However, the foreign spouse is legally barred from working in the United States until an employment authorization document or green card is issued. This restriction applies even to remote self-employment serving non-U.S. clients if the productive activity occurs while physically present in the United States. Attempting to work during the waiting period can jeopardize the case. Additionally, using a visitor visa with a preconceived intent to adjust status may be considered fraud or misrepresentation, creating serious immigration consequences. With those risks in mind, we will map the AOS waiting period flow next. This flowchart illustrates the adjustment of status path. The sequence begins with entering the United States on a K-1 fiancé visa, or, more riskily, a visitor visa. The next step is marriage in the United States, followed by filing the adjustment package, typically including Forms I-485 and I-765. Then a wait period of several months ensues. During this wait, the foreign spouse is not authorized to work, which creates a financial gap. After the EAD or green card is approved, the spouse can work legally. This visualization emphasizes the economic risk built into Option 1 for self-employed individuals. Turning to Option 2, consular processing begins with marriage outside the United States. The U.S. citizen spouse files the I-130 petition, after which the National Visa Center processes the case, and the foreign spouse attends a consular interview. Upon issuance of a County Route 1 or IR1 immigrant visa and entry to the United States, the foreign spouse becomes a permanent resident and can work immediately. The primary drawback is separation during the processing time, commonly 12 to 18 months. A major benefit for the self-employed is the ability to continue working legally in the home country during the wait. Additionally, the U.S. sponsor must maintain or re-establish U.S. domicile, which can include evidence such as a U.S. address, job offer, voter registration, or other ties. Next, we will visualize timelines to compare expectations. This table summarizes key comparisons. Option 1 allows couples to be together quickly, but does not allow work until the EAD or green card is issued, typically 6 months or more, with potentially significant legal risk if a visitor visa is used improperly. Option 2 requires separation, but once admitted, the foreign spouse can work immediately, and the legal risk is lower. Direct consular filing may yield faster consular outcomes if accepted, but eligibility is rare and discretionary. Direct consular filing is a narrow pathway intended for emergencies or exceptional situations. Examples include urgent employer-driven returns to the United States or significant medical crises. If a consulate agrees to accept a direct I-130 filing, processing can be much faster than the standard consular route. However, acceptance is discretionary, case-specific, and not guaranteed. Couples should only pursue this if they can document a compelling and exceptional need. Next, let us compare Option 1 and Option 2 head-to-head. Here is a side-by-side comparison. Option 1 reunites couples quickly, but imposes a work blackout until employment authorization is granted, which can disrupt a self-employed career and introduce legal risk if a visitor visa is misused. Option 2 requires a longer separation, but enables the foreign spouse to enter as a permanent resident with immediate work authorization, typically reducing legal exposure and protecting the income stream. With that contrast established, we will outline practical steps to decide. To decide, start by clarifying priorities. If maintaining income is non-negotiable, Option 2 is often the prudent choice. Next, consider your timeline for cohabitation and whether you can handle a work blackout under Option 1. Evaluate whether you might legitimately qualify for direct consular filing by documenting exceptional urgency. In parallel, plan for the U.S. domicile requirement by gathering proof such as a lease, utility bills, a job offer, or other ties. Finally, consult an immigration attorney to assess your situation before filing. Next, we will visualize how timelines can play out. This timeline diagram lays out typical milestones. Adjustment of status involves filing after arrival and waiting several months for employment authorizations. Consular processing spans the I-130, National Visa Center, and consular interview, often totaling 12 to 18 months before entry as a permanent resident. Direct consular filing, if accepted, may compress the schedule to a few months. Processing times vary widely depending on jurisdiction, caseload, and case-specific reviews. Always plan for possible delays and consider a financial safety net if you pursue Option 1. Now let us test your understanding with a quick quiz. Question 1. Which option typically allows the foreign spouse to work legally from day one upon U.S. entry? Option A. Option 1, K1 or AOS. Option B. Option 2, Consular Processing. Option C. Enter on a visitor visa and freelance remotely. Or Option D. Door 3 DCF never allows day one work. You may pause the video now to think about your answer. We will discuss the answer in the next section. The correct answer is B. Option 2. Under the County Route 1, or IR1 visa, the foreign spouse enters the United States as a permanent resident with work authorization from day one. Options A and C do not provide that immediate legal authorization, and attempting to work on a visitor visa is not permitted. Question 2. During adjustment of status, can a self-employed foreign spouse continue working for non-U.S. clients while physically in the United States before receiving an EAD? Option A, yes, because it is not a U.S. employer. Option B, yes, if paid to a foreign bank. Option C, no, because it is generally considered unauthorized work. Or Option D, yes, if under 20 hours per week. You may pause the video now to consider your response. We will provide the answer in the next section. The correct answer is C. During adjustment of status, productive work performed while physically present in the United States is generally unauthorized until the EAD or green card is issued, even if the clients or payments are outside the country. Here are the key takeaways. First, if maintaining income is essential, consular processing is generally the most responsible choice. Second, avoid misuse of visitor visas, as preconceived immigrant intent can lead to fraud findings. Third, direct consular filing is rare and discretionary and should only be pursued with documented exceptional urgency. Fourth, the U.S. sponsor must demonstrate U.S. domicile. Finally, if you opt for adjustment of status, plan a financial runway to cover the period without employment authorization. Next, we will summarize and close. In summary, couples face a genuine trade-off between speed and income security. Option 1 reunites you sooner but prevents legal work until authorization is granted. Option 2 delays cohabitation but ensures immediate work authorization and lower legal exposure. Direct consular filing exists for exceptional cases but is uncommon. Plan for U.S. domicile, realistic timelines, and financial buffers. Always consult a qualified immigration attorney to tailor the approach to your circumstances. Finally, we will close with a call to action. Thank you for watching. If you found this useful, please like the video, share it with someone facing this decision, and subscribe for more practical immigration guides. In the comments, share your situation, your questions, and which path you are considering. Your experiences can help others, and your questions may shape future videos.